Cardenas Jr. And Mr. Cardenas was previously in court, entered a plea of guilty in cause number 26 DCCR 0040 to the third-degree felony offense of injury to a child, elderly, or disabled individual. And that was for an agreement of 5 years deferred probation. I received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Any additions or corrections?
Not from the defense.
Judge, my only position would be that obviously as indicated by the PSI, this incident does not stem from his criminal history, so to speak, but more likely probably a mental health or a narcotics-induced incident. It's obviously concerning with regard to his father. We'd ask that a no contact order remain in place, but defer to what you think is appropriate.
Okay, so Mr. Cardenas, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes, among other things, but that does include that you will enter and successfully complete the safety program. So that can help you with any drug or alcohol related issues. When you get out, you will also be placed on the mental health initiative caseload to help with any other issues that you may be having, so that you will have all the tools to be able to be sober, healthy, and obviously not have anything like this happen again.
Yes, ma'am.
You will also be required at this time to have no contact or communication with Manuel Cardenas Sr., your father. That's until further order of the court. And so if there becomes a time on probation where you feel like you're in a good place and he wants you to be around or something like that, you have to go through probation. You have to get my permission to do that. He can't give you permission.
Okay.
So he can't say it's fine, come over, it's Christmas. If you do that without my permission, it's a violation of your probation. Okay. If you do everything you're supposed to on this probation, you're about to get all the tools you need to be successful. You don't have a felony conviction. You should be able to finish it. And at the end of your probation, if you're successful, the case is actually dismissed. You'll never have a felony conviction on your record.
Sounds good.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and I could send you to prison for anywhere in the punishment range, which is between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. Good luck to you, sir.
Okay.
Good morning. Are you Jimmy Couch?
Yes, ma'am.
Y'all give me just a second.
We're gonna like a statue. We can know that it's attempted.
Yes, we
That's coming. Mr. Couch,
Yes, ma'am.
pay attention this way. All right. Will he waive the formal reading of the indictment?
He will, Your Honor.
Mr. Couch, in clause number 26, DCCR 0328, the state has elected to proceed on the lesser included offense of the third-degree felony attempted burglary of a habitation. And that's from January 29th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine. You'll be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Oh, yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Couch is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. Ms. Malfino?
Judge, the state would respectfully object to any type of PSI bond in this case because of the fact that we're going to very strongly urge the court to consider safety. I have met multiple times with the complainant, Ms. Couch, in this case. She is actually present in court today. I think there is an underlying severe substance abuse issue that has contributed to all of these issues, and that will be the position of the state to ask for safety. And I'm afraid that if he's out in the interim, it will derail that and also this absence of contact with her at this point.
So
I understand that's the state's position.
Sure.
Mr. Couch is requesting that you do consider allowing him to be released. He's been in jail now for 4 months. He's getting some taking AA classes in jail.
Rocco.
He's got some health issues that he desperately wants to get on the outside and
Yes, ma'am.
interest.
I have a spot on my lung. I was supposed to be in Baptist Hospital for another PET scan and another biopsy. And it's just getting worse by the day.
well, if Mr. Rojas, if you want to get some information to the court between now and sentencing, I can bump something up with regard to a bond hearing. But today, based on the allegations and the concern, what I'm going to do is not change the bond. I am going to ask probation to do go ahead and get a substance abuse assessment during that so that we have everything in place when we come back for sentencing. All right, you can go back with the bailiff.
Okay, thank you.
And will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Hulsman, in cause number 26 DCCR 0199, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault, and that's from January 7th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, sure.
Do you fully understand them?
Sure.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for, hold on, it's back. A 2-year deferred probation. There would be a $250 fine, and you would be required to follow all of the rules and conditions of probation. Part of that would be that you would follow any recommendations with regard to any mental health care issues. Do you understand? State tenders number 1.
No objection.
It's admitted. And are you a U.S. citizen? All right. Is there any evidence that Ms. Hulsman is not competent?
None that has not already been addressed, Judge.
Okay. All right, then, Ms. Hulsman, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of the plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $250 fine, and you're ordered to follow all of the rules and conditions of probation, including any mental health care. If you do all of that, this is a great opportunity because you won't have a conviction on your record. And at the end of the probation period, if you successfully complete it, the case is dismissed. The other side of that is if you violate any condition of probation, you can be brought back in the court and you could be convicted and sent to our Jefferson County Jail for up to 1 year. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You'll get some instructions from probation today so that you'll know exactly what to do when you're released from jail. Make sure you do all that, okay? All right, you can go back. Mr. Lewing is charged in cause number 25 DCCR 1402 with the state jail felony offense of unauthorized use of a vehicle. Ms. Shipley's here for Mr. Smith, and is there an announcement?
Judge, yes, Your Honor. Mr. Smith had to be in another court, and so Mr. Lewing and Mr. Smith have been working on some things, and they were able to provide Ms. Malfino with some additional information. And we're asking for a little bit of time for Mr. Smith and Ms. Malfino to consult on those matters.
And Judge, I have spoken with Ms. Shipley this morning. That is correct. Mr. Smith sent me an email from the defendant yesterday. And since he's here, if I may, I would just like the defendant to know I have taken it into consideration. I have rewatched the video, although there is a portion of his email that I agree with respect to the ski mask. I just want him to know where I'm coming from.
Sure.
His stack of felonies that is this high doesn't lead me to take everything he says in that email that is self-serving to heart, but I will, based on that, be willing to discuss with Mr. Smith reconsideration of the offer if the court would allow us that time. But I just wanted Mr. Lewing to know I did look at that and what my position is.
Okay, so we'll just do a normal reset. That'll give your attorney and time to visit with Ms. Malfino, and when we come back, we'll get an announcement at that next court date.
Thank you.
Thank you, Judge. And then Mr. Smith will be out to see you as soon as he meets with Ms. Malfino. Thank you.
Good morning. You're Breanne Williams?
Yes, ma'am.
And this is cause numbers 26 DCCR, 0531. Ms. Williams entered a plea of guilty in that case to a new offense of possession of a controlled substance, a third-degree felony. And then we've got cause number 1830512. Ms. Williams is on probation for injury to a child, and that's a third-degree felony offense. Entered pleas of true. Let's see, I see where. While I look at that, but there was an agreement, it appears, for a 3-year deferred probation, $500 fine, and ISF substance abuse track on the new case with continuing probation and ordering substance abuse, ISF substance abuse on that one. I've received the pre-sentence report and gone over it. Have y'all both had an opportunity to review that report?
Yes, Your Honor.
Yes, Judge.
Let me go back and look at something. All right, so it was a 10-year deferred probation from May 20th, 2019 for that injury to a child or elderly, individual. And it looks like she pled true to counts 1 through 5, which include that new offense of failure to identify, a new offense of public intoxication, being an out past curfew, and court assessed fees. So I guess what I have a question mark here and an issue and a question, which is why is it just 3 years on a third degree felony possession when we've already got a 10-year deferred on the other one? I just don't know that makes sense to me for it to be that low of a number of years for a new offense while you're on a felony offense. I'm not opposed to the ISF and do it and going forward with probation, but I just don't think it makes sense to do
It could have been the length of time.
That she had already been.
Right, because the new case, the new offense was from 2024, did not get indicted until this year. So I think that played a part.
Okay.
In it.
But it was, okay. But it still was after she was on probation,
Yes,
but it
it
didn't
is.
get indicted for
And
a
I
long time.
believe when it originally occurred, that was addressed at a previous MTRP hearing, but it did not get indicted till 2 years later.
Okay. All right. Anything else then?
No, Your Honor.
No.
All right, Ms. Williams, with that explanation, I'm going to follow the agreements that you made with the district attorney's office. And cause number 26 DCCR 0531, find sufficient evidence to find you guilty. However, I'm going to follow that agreement and in that case, defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes injuring and successfully completing the substance abuse track of the of ISF. And then in clause number 18-30512, I'm going to find that you enter those pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation in that case, but I'm not going to do that. I'm going to follow the agreement, continue you on probation, order as a condition of that probation that you enter and successfully complete the ISF substance abuse track as well. You're being given now all the opportunities that you're probably going to be given. So you're going to go to ISF. You'll get the tools you need in order to remain sober. When you get out, you'll have aftercare. You still have no felony convictions. You still got some great opportunities here to kind of get your life back on track, get off drugs, and just live a normal life. If you don't do that and you don't take advantage of this and you continue to test positive and do the things that you did on this one, you're going to end up back in here, and you could go to prison in each of these cases for up to 10 years. So you understand?
Yes, ma'am.
All right, I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, and so you waived your right to appeal. Good luck to you, ma'am.
Yes, ma'am. Thank you, Judge.
Are you Carl Farrow?
Yes, ma'am.
This is 26 DCCR 0100. Mr. Farrow is charged with the state jail felony offense of unlawful possession of certain copper or brass material from October 30th of 2025. And what is the announcement?
Your Honor, if we can get a little bit more time. I've met with Mr. Farrow. This case involves whether he had authorization to possess these copper materials, and he's relayed to me that he does have documentation that had given him the authorization. And so if we could have some time so that he could get that to me.
Okay.
Yes, ma'am.
All right. So I'm going to do a normal reset. Mr. Farrow, make sure whatever information you have, you get that, or your family or someone gets that to Ms. Holmes as quickly as possible so that she can then visit with Mr. Smith about it, and then I'll be back out to visit with you before that court date.
Thank you.
All right. You can go back with the bailiff about that. Good morning. Are you Donnie Glenn Smith?
Yes, ma'am.
And this is cause number 26 DCCR 0072. Mr. Smith is charged with assault on a peace officer. And what is the announcement?
Well, Your Honor, he had previously pled, but he didn't appear for his sentencing.
Oh,
And so,
okay.
yes, ma'am. So we had done all that, but he didn't appear.
He pled, Judge, that there was no agreement as to the type of probation.
Do
Or
you have
The
a-
type and
at the time.
Is there a PSI? It shows a status hearing, but I should have, it was set for sentencing and he didn't show up. And so there was a bond forfeiture. So I should have a PSI on Donnie Smith. It's not in the case.
I've got you.
No, because I'll have notes and,
okay.
all right, just, y'all can hold him for a few minutes. Let me, Bork.
Yep.
And this is 25 DCCR 1213. Mr. Bork is charged with the state jail felony offense, excuse me, of theft of property. That indictment alleges 3 prior state jail felonies from different dates, which means for punishment purposes, this could be considered a 3rd-degree felony with a punishment range of between 2 years and up to 10 years. And Mr. Lewis, what is the announcement?
Judge, initially came in planning to place this on the trial docket, but after speaking with Mr. Bullock this morning, I guess after his conversations with his family, they'll be able to retain his own attorney.
Okay.
So I would ask that he at least have that opportunity, at least one setting before the case is placed on the trial.
So, Mr. Bork, I'll reset your case to normal reset, which is about 30 days. Mr. Lewis is going to remain as your attorney unless you get someone else hired. If you do, they'll file the appropriate paperwork to substitute in for him. If for some reason that doesn't happen before the next court date, then we'll need to go forward with you visiting with Mr. Lewis and see where we get on your case, okay?
Yes, ma'am. Can I ask a question?
What's that?
My time wouldn't go up. I mean, I should be able to get a lawyer, but my time wouldn't go up like I'm playing with you or nothing like that.
No, there's been no reduction.
The offer is what the offer is. It's probably,
Okay.
it's not going up or down at this point for any reason. If he wants to get his own attorney, he has that right. I'm not
Okay.
putting that against him.
Sure.
Thanks.
So that'll remain on the table. That's between y'all at this point.